Prosecution of offenses. Section 1, prosecution, institution of criminal actions. The section stated that the offenses outside the Metro Manila um, has a 6 years and 1 day. Should have a preliminary investigation, and the offenses have a not unless 6 years and 1 day should file the complainer information to municipal trial court, municipal circuit trial court, or office of the prosecutor. And the section 2, which is the complainer information must be in writing. Second, it must be name of the Philippines. And third is the of um, all against person who appear responsible of the offenses. And then the section 3 and 4, which is the complaint information. Is a complaint, it is a sworn written statement charging a person with an offense prescribed by the offended party. And then the information, it is a sworn written statement charging a person with an offense, charging a person with an offense, and um, prescribed by the um, any public officers or the public prosecutor. And the general rule of the section 5, which is the general rule of the prosecutor, which is the public prosecutor must prosecute all of the what we call the criminal action, which is at he has its exemption. The exemption first, it is the private prosecutor can prosecute civil action, criminal action, if the in case if the public prosecutor have a heavy work or have an a lot of schedules. And then second if the there is no available public prosecutor or lack of public prosecutor. And then in the second paragraph on the section 5, which is the concubinage and adultery, it shall be it can be prosecuted if the spouse will file a complaint or information. And the seduction, abduction, and act of lasciviousness, it can be prosecuted if the parents, grandparents, or guardian, or the state may file a complaint or information. So in section 6 to 12, stated the sufficiency of the complaint or information. Rule 111, prosecution of civil action. According to section 1 of this rule, when the criminal action is instituted, the civil liability shall be deemed instituted. That is a general rule of this rule, but it has exception. The first exception, it is if the offended party waives their civil action. Second, if the offended party received the right to institute it separately. And the third, if the institution of civil action is prior to criminal action. Rule 112, preliminary investigation. According to section 1, preliminary investigation, it is a inquiry or proceeding to determine whether there is an probable cause to the crime has been committed. And then and the preliminary investigation is required to be conducted before filing a complaint or information. And which have a penalty of 6 years and 1 day. in imprisonment. 113 arrest. Um, in section 1, arrest, it is a taking a person to custody and in order he may be bound to answer commission of offenses. In section 4, um, um, the execution of warrant within 10 days, and then the after the period of the execution of warrant, which is the 10 days, the peace officer should or shall report to the judge, and if the peace officer failure to execute the warrant, the peace officer he state the reasons. And in section 5, which is a peace officer uh, can um, can arrest a person without a warrant. First, it is a first is infraganti delicto or cuff in the act, and then second is a um, had pursuit or personal knowledge, and third is keep a prisoner. Rule 114, bail. In section 1, bail, it is a security given to release a person in a custody of the law, and then furnished by ombudsman to guarantee his appearance before any court. According to section 2, all person can avail, or all person have an offense can avail to bail, except have to those people who have offenses punishable by reclusion perpetua, death penalty, and life imprisonment. According to section 4, bail is a matter of right after and before conviction by the municipal trial court, metropolitan trial court, municipal circuit trial court, and before conviction of regional trial court, not punishable by LDR, which is reclusion perpetua, death penalty, and life imprisonment. Rule 115, right of the accused. The accused in a criminal prosecution have a several rights, including first, the presumption of innocence. Second is a right to inform of nature and causes of accusation. Third, it is a right to present and defend themselves. And fourth, it is a the accused can testify as a witness on their behalf, and etc. Rule 116, arraignment and plea. Um, in paragraph A, section 1, the accused must be arraigned before the court where the complainant information where the complainer information as is filed and or designed for trial, and then the arraignment shall be made in open court by the judge, giving the accused a copy of complaint or information, and reading it in the same dialect of the accused, and asking the accused if he's plead guilty or not guilty. In paragraph B stated that the accused must be present in arraignment and personally um, enter his plea. In paragraph C, if the accused refused to his plead, the um, the not guilty shall be entered for him. And in paragraph D, if the accused plead guilty and present exculpatory evidence, the accused, the plea shall be withdrawn, and um, drawn and the not plead guilty is entered for him. Rule 1117. Um, Motion to quash. Motion to quash is can move anytime to motion to quash the information or complaint before entering his plea. And motion to quash must be writing and must be signed by the accused or the counsel. And third, the most important is the distinctly specify the functional of and the legal grounds. And then according to this rule, there are 9 legal grounds for that the accused can move to quash. First is the facts of the charges is not constituted an offense. Second, the court is trying the case has no jurisdiction over the accused. And the third, the officer who filed information does not authority to do so, and etc. Rule 118, pre-trial. Pre-trial is a mandatory in criminal cases, which is reason is to avoid surprises. And in a pre-trial, both of the parties may lay down all the evidence, witnesses, and failure to present those on pre-trial or could be not be admitted to the trial. And then the trial, yes, otherwise the for the good causes. And then um in pre-trial there will be a plea bargaining, stipulation of facts, and decision of facts, and mm, markings and identifications of the evidence, a waiver if objection, um, or admissibility of evidence, and last is the modification of the um, order of trial with the accused admit his charges. And then in section 2 is stipulated there that all in arraignment and admissions shall be reduced in writing and signed by the accused and the counsel, and if they failure to do so, they cannot use it against the accused. And then of appearance of the accused and the counsel in the trial, in the pre-trial, the court may impose a penalties for them. Rule 119, trial. Um, According to the section 1, the time to prepare trial is after a plea not guilty is entered, and the accused have a 15 days to prepare for the trial, and the trial shall commence within the 15 days from the received pre-trial order. In section 3, stated there that the delay of the trial shall be excluded in computing the time within when the delay or other proceedings concerning the accused delay resulting from mental incompetence, physical inability, and if that the accused can stand in the trial, if the information dismissed upon motion of prosecution. Section 11, the order trial first when the prosecution shall present the evidence to prove the charges, and the accused and the defense have a rebuttal or rebuttal for evidence, then we shall for submitted for decision. Section 23, the demur of evidence. It was after the prosecution rest its case, and the court may dismiss the action of the ground of insufficient evidence. Rule 120, judgment. According to the section 1, judgment is a adjudication by the court that the accused guilty or not guilty of the offense charge. Then the imposition in the imposition of him a proper penalty and civil liability. Rule 121, new trial or reconsideration. And in section 1 of this rule, the new trial or recommendation, it may happen anytime before the judgment of conviction becomes final. And then in section 2, the new trial or reconsideration becomes is if there's error of the law, and second, if there's a new material evidence has been discovered. Rule 122, which appeal. In section 1, the any party may appeal from the judgment or final order unless the accused may please to double jeopardy. In section 2, where to appeal. First level, which is the court, which is the MTC. When from MTC, go to RTC. When from RTC, go to the Court of the Appeals. Then from the Court of the Appeals, go to Supreme Court. Rule 126, cease and seizure. Search warrant defined. An order writing a name of the people of the Philippines signed by the judge and directed to peace officer and commanding him to search a personal property and describe therein, bring it before the court. The property to be seized according to section 3 are embezzlement property or intended or used or intended to be used means committing an offense. In section 7, the search warrant not be issued except upon the probable cause in connection with one offense determined personally by the judge, and it should be found in section 4. And additionally, in section 7, the police officer must identify themselves and announce their purpose before using a force, and then apply a brake, and then announce the doctrine.